Hello, good afternoon, and welcome to another edition of Covered Under Law. This is your legal light and health law in these trying times. So today, we are treating the topic Termination in Covered Era. How should both employers and employees conduct themselves or handle issues of termination, as it were, letting people off the work in covered times? Share your questions and experiences with us as we undertake this education. We'll be right back. Yeah, welcome back. And that was an interesting discussion there about employment law. And here we are having ours. And we are privileged to have joining us this afternoon for Covered Under Law, Charles Bawadua. And Charles Bawadua is a private legal practitioner. He has been practicing for many years with a focus in this particular area of labor and employment matters, and is the former executive secretary of the National Labour Commission. Thank you, Charles, for making time to join us.
You're most welcome, Samson.
Great. All right, so as you know, get ready with your questions. If you have been terminated, the circumstances of your termination, share them with us. If you need help, how can you get the help, particularly resorting to the Labour Commission or going to the court or what? Let us know what your situation is. And we're dealing with a man who was the head of the Labour Commission of Ghana. So you're rest assured that you can get the best of solutions to your issues. So to start with, of course, we heard the gentleman in the news round discuss termination with cause or without cause. In our situation, it would be a matter of a reference to the Constitution, I think Article 17 or thereabouts or so. So what do you think, and how should employers be handling situations of termination in these times, very difficult times?
Thank you very much, Samson. Just before I answer your question or seek to explain what ought to be done,
okay,
I want to spend a minute of your time to express my condolences to the family of the old lady who was recently lynched,
right,
in the Savannah region.
Right. There's a campaign mounting, Justice for Grandma.
It's most disgusting. I think that we have moved beyond this as a country, and especially for those of us from northern Ghana. We must grow. And I think that times have changed.
The police actually confirmed that she was killed in trial by ordeal,
yes,
having been said to be a witch.
Yes, when I was growing, I heard these things, but I do not believe that this is still being done. I think that we must mount an education, apart from bringing to book and justice those who have committed this offense. We should launch education. For this to happen, it appears to me then that we haven't done enough by way of education.
Okay.
Clearly, the whole of Africa came up from a certain background, but times are changing. We have reached a stage where this shouldn't happen. So
okay,
let's see what we can all do to get justice for the family and to ensure that this doesn't happen in the future.
Thank you very much. Well, that's good advice to all of you watching us, particularly watching us from that part of the country in the Savannah region, particularly in Kafaba. But we know that there are other people elsewhere who may be tempted to engage in trial by ordeal. You ought to know that our law prohibits it. The Criminal and Other Offences Act prohibits trial by ordeal. And it actually says that a person who directs or controls or presides at a trial by ordeal is guilty of a second-degree felony, which means if you are taken to court, you could be, and you are found guilty, you could go to jail for 10 years for that kind of act. Or for those of you also who were around, just watching, or who took some part in the process, you have also committed an offense which is a misdemeanor, and you could go to jail for up to 3 years. But if the police decided to actually try the person who were at the forefront and kill the woman under our felony laws as a felony, as a murder case, then you are looking for death. You'll be punished with death. And those of you who are watching, the law puts a duty on you to have prevented the felony. And for failing to prevent the felony, you could also go to jail for 3 years. Our appeal to the police in that region, the Savannah region, is that stop giving excuses. Go get these people. We have seen some of them in the videos. So stop saying you are looking for the right culprits. Arrest those who are observing. Arrest those who are participating by encouraging it, because they are also guilty. Pick one of those people. They will lead you to the one who was doing the killing. Thank you. And thank you very much to Charles Bawadia for making time to draw our attention to this. All of us must stand against it. All right. So, first, I was asking, how should employers handle cases of seeking to lay people off or simply terminate them? And in the course of the discussion, you will explain to us the differences between, is it a laying off, termination, or is it whatever it is?
Yes. It's a truism that coronavirus has hit the world hard. Almost everybody is affected.
Right.
Whether your movement, your workplace, or whatever you do, you've been affected by one way or the other. Labor is not left out.
Okay.
The employer-employee relations has also been hit hard. With most organizations who cannot withstand the impact of coronavirus on their books, laying off workers, some doing so properly, some without any recourse to any procedure.
Yeah.
In recent times, I've heard, especially some private school teachers, complain bitterly that the employer has refused to pay them. Some say, they now give them half of their salary.
That's right.
Others say they should go home and come when things improve. And others were written to not to come again. And in all this, without any proper procedure.
Okay.
Now, let me say that our laws on these issues, are adequate to deal with the situation.
All right.
I do not believe that because coronavirus is a new phenomenon, no laws exist that deal with the situation. That's not correct. First of all, you see, coronavirus, the effect of it has been to bring down certain companies and organizations in terms of their normal operations, thereby affecting their ability to, produce and to get the necessary returns to be able to pay their workers.
Exactly.
In fact, in the case of some organizations, they don't go to work at all. Take, for example, those in the aviation industry.
Right.
The majority of them are at home now, not doing any work.
Borders have been closed.
Yeah,
no
borders
flights.
have been closed, no movement. The tourism industry, tour operators and all that. Not forgetting about the educational sector as well.
If the children are not going to school, then teachers will not be needed.
Exactly.
Yeah, so at least not in the numbers that you expect.
Yes, so for most people, the way forward is to just say, go home, we are not working. But that's not the situation. You see, what has occasioned brings into focus our law on redundancy.
Okay.
Because if you look at what redundancy is about when the organization ceases operation for whatever reason, or it no longer requires a certain number of workers. and has to cut down the number of workers.
Okay.
Or there's some reorganization, structural adjustment, or the employer now thinks that, let me switch to some other kind of production.
Okay.
There's changes.
All right.
Now, if you take COVID,
I just realized that what you just said is a perfect definition of what the law says is redundancy.
Sure.
So if you don't mind, let me just read that.
Very well.
So that you know that we're actually dealing with a custodian of the law. So he just mentioned that some of the situations are perfect situations of redundancy. And instead of just asking people to go away, this is the procedure that may be followed. And he started to define redundancy, which is in the law, section 65 of the Labor Act of Ghana, 2003, says redundancy when an employer contemplates the introduction of major changes in production, program, organization, structure, or technology of an undertaking that are likely to entail terminations of employment of workers in the undertaking, then the employer shall do a number of things. Okay.
Yes, I think you should add subsection 2, the first part of it,
right.
The next page.
Without prejudice to subsection 1, where an undertaking is closed down or undergoes an arrangement or amalgamation, and the closed down arrangement or amalgamation causes severance of the legal relationship, among other things.
Yes.
Right.
So those are the situations that redundancies will arrive. So COVID has succeeded in closing down certain organizations.
Okay.
This is not the fault of the employee. Now, as it is, what will be required is that for some organizations, already in their collective agreement is the documents that where you have a union, it will normally sign between the workers and the management as the terms that govern the employment. Okay. Under the old law, it used to be called collective bargaining agreement. Some people still call it, but the appropriate term now is collective agreement.
Okay.
Now, so in the collective agreement, normally you have certain procedures, provisions contained therein as to what is to be done in a situation like that. Okay. So if everybody is supposed to be paid the 1 month salary for every year served, or a week's salary, depending on whatever is contained in the collective agreement. So what we'll be doing now will be to invoke the provisions of the collective agreement.
I have seen some collective agreements, and in some of them, you see that the provision in this current circumstance is that in addition to all the benefits you get, say, if you have done, say, 5 years in the employment, or if you have done, say, 10 years in the employment, depending on the number of years you have done, you could get as much as 2 months' salary for each year of work. There are people who get about, say, 3 months' salary for each year of work. So if they had done 10 years of service with that company or employment, and it's being closed down, as you refer to, in this kind of circumstance, then they will be entitled, apart from all other benefits, to 3 months' salary for each year of service. That is 3 times 10.
Yes.
All salaries put together. That's enough money to set the person up.
Sure, that's enough money to set the person up. And you have some too where it is that bad. They will say 1 week salary for each year served.
1 week salary for each year
all
served.
These things depend on the terms of the collective agreement.
Right.
So in a situation like that, the provisions of the collective agreement will apply.
Okay.
But let's not forget that what COVID has done is to make the employers very poor. So if you have a situation where the quantum of compensation that we are computing now is such that the employer cannot pay, what do you do? So let me say that the operation of collective agreements is not in a vacuum. Okay. That is why under the law, the employer-employee relationship is supposed to be one of good faith.
Good faith.
Yes. The employer providing the employees the kind of information that they need to know. that will inform them as to what demands to make.
Okay.
So if it's obvious that in this COVID era, it's not practical, in fact, virtually impossible for the employers to be able to meet those sums of money or whatever entitlements they are, because the collective agreement is an agreement between parties, it can always be varied.
Okay.
But mind you, it cannot be varied unilaterally.
Okay. It must be consensual.
Yes, consensual.
Mutually.
Mutually. Both parties coming together so that, look, this is the situation we faced.
But you know that often in these circumstances, the employee often takes an intransigent position, doesn't want the benefit he or she is going to get to reduce.
Yes. So you see, these situations will normally arise where the employee doesn't have the full information of what is in the system. That is why it's important to share information.
Okay.
I do not think that a union or an association of workers or an employee will be so outrageous to say, notwithstanding that you cannot afford, you must pay this. It's about the mutual interest of both parties.
Okay.
So when it comes to this, even though you may have these provisions, the collective agreement, they are amenable to renegotiation by the agreement of both parties. But let me also say that it is not in every organization or at every workplace that you will have collective agreements. In the majority of cases, they don't even have unions. Some don't even have contracts of employment.
Okay.
You see? So under that circumstance, the law enjoins the worker and the employer to sit down and negotiate. Because there is no existing provisions, existing terms of employment that relate to the situation.
Okay.
The law says the parties should sit down and negotiate.
Right. So you're talking, because we know of many situations where people are just handed a letter of employment, and that's the end of it. They don't get anything in addition to that. The company doesn't have any document that contains the various other conditions of service and obligations to the employer, employers, and employees. So where there are unions, there are associations, they are able to get the collective agreement.
Sure.
But where there is not, often these don't exist. That's where you say, in that situation, you sit down and negotiate.
You negotiate when the situation that brings about redundancies occur.
Okay.
You need to, that's what the law actually says. You negotiate. If there is agreement, you sign and execute.
Okay.
If there is no agreement, you are enjoined to proceed to the National Labour Commission.
Okay.
For the commission to now hear the parties and determine what is reasonable under the circumstances.
So if we sit down, myself and my employer sit down, and we can't agree, then the way to go is that I should initiate a process to take the matter to the National Labour
Commission. Or even the employer, because the law says either party to the negotiations can make a complaint before the National Labour Commission for the redundancy pay to be assessed, to be determined. Now, let me say that, you see, therein you see the advantage of belonging to trade unions.
Right.
Because when you belong to a trade union, the union will negotiate all the necessary terms of employment for you. So that you will hardly have a situation where there's no provision in your collective agreement that covers it.
Okay.
But in situations where you don't belong to a trade union, you are found in a difficult situation. Now, under the law, the employer is actually enjoined to provide a contract of employment that contains the details of the terms of employment to the employee.
All right.
In fact, the Act provides a certain schedule which contains some of the nitty-gritties that must be in the employment contract. Now, this contract, when signed, constitutes your terms. And it's reference to it that you will make whenever there's an issue that arises regarding your employment. All right. So this is important, and workers must take this seriously. And also employers, because you do not operate in a vacuum. The law applies.
So you are talking about a situation where, because of COVID, the employer is going to lay off a good number of people, not just one person.
No.
But if the employer's decision is that, well, I'm going to terminate people, and by law, the employer is entitled to terminate you.
Yes.
So there are about 10 people the employer wants to terminate. So terminates this one this week, terminates the other one the next week, terminates until the employer gets rid of 10 people, so that there's a sizable number of people to manage. Yes. Is there anything wrong with that?
That's an interesting area. You know, that's what some people have sought to do, because you know the existence of this common law principle of terminating by giving notice.
Right.
You know, so they think that, oh, when I no longer need the employee or the worker, I was okay, under our contract of employment, I'm supposed to give you 1 month notice, or Section 17 of the Labor Act, I'm supposed to give you 1 month notice and all that.
Okay.
So instead of going, you know, into redundancy issues, they will take this approach and to avoid costs. But that's wrong. You see,
why is it wrong?
Because
the same way that the employer is entitled to terminate me is the same way that I, the employee, can get up one day and say, I'm no longer interested, I don't want to work with you anymore. And I can also give 1 month notice or pay the 1 month salary in lieu of the notice and get out of the employment. So why is it that the employer, when it comes to the employer, you say it is wrong?
Great. Employment relations is regulated by law.
Okay.
Of course, a contract of service, not a contract of servitude.
All right.
So you cannot enforce or compel a worker to work with a particular organization. Neither can you compel a particular organization to keep a particular worker. Good. But these things are regulated by statute. Now, if you look at Section 15 of the Act, it provides grounds by which you can terminate the employment of a worker.
Okay.
You know, mutual agreement, sickness, incompetence of the worker, death, gross or proven misconduct of the worker, sickness and all that. Now, then you have Section 17, which talks about notice. And because Section 17 is not linked to Section 15, a certain school of thought has it that, well, once I'm able to give the notice, I do not need to give reason for termination. You understand? So they go strictly by saying that I no longer need your service, and pay you 1 month's salary and all that. That is the approach you were describing.
Okay.
Now, this is wrong because in this act, you have fair and unfair termination of employment. In this same act, you have redundancies as we have described. Now, it is in the reason for the termination that you will know whether this is not a redundancy in disguise, or whether it is not an unfair termination, or whether it's a fair termination. You understand? So if the reason is not provided, you are not capable of knowing what rights I have under this termination.
But I, the employee,
I'll come to that.
I can decide to move and I won't give you any reason.
Exactly.
If, like you just said, the employment relationship is one of service and not servitude.
Yes.
That in the same way, the employer should have a right to terminate me without giving me reasons.
So the position now is this. Even though the employer can terminate without giving the reason, if the employee challenges the termination, the employer is due to bound to give the reason and justify the termination.
And in giving the reason,
exactly,
then you will find out, or the law will find out whether it is fair or it's not fair.
Or whether it's a redundancy.
Okay, so if it is found out that the termination is unfair, what will be some of the grounds to come to a conclusion that the termination is unfair? And if it is determined that it's unfair, what will happen?
Fine. So in looking at whether you have a fair or an unfair termination, Section 63 particularly deals with those provisions.
I was smiling. The way he's quoting the various sections, I am trying to open when he's quoting. All right, go ahead.
Well, I eat and drink the act. So.
Okay. All right, go ahead.
Yeah, so that is it. So you talk about the
grounds of unfair termination.
There is a full list there.
Right.
Yes. So a situation, for example, you terminate the worker's employment because he has joined a trade union or intends to join a trade union.
In fact, in the law, that's the first ground.
Yes, it's one of the very many ways that employers use to victimize workers when it comes to employment.
Okay.
Because especially those who don't want unions in their organization. So when you go and you start forming a union, they just find ways of throwing you out because you are coming, they think you are coming to cause trouble, which is not the case. Because in situations, in organizations that you actually have unions, the relationship with the employer is better, more organized than where you don't have at all. Rights are observed, and the workers are better controlled.
Let's go through the list. You have mentioned it is unfair termination. If you are terminated, it is deemed to be unfair if you are terminated because you have joined a trade union or you intend to take part in the activities of a trade union. Yes. Number 2,
the worker seeks office or is acting or has acted in the capacity of a worker's representative. That's also related to union activity. That the worker has filed a complaint or participated in proceedings against the employer involving alleged violations of this act. So, for example, you think that your employer is not treating well, you go and make a complaint at the National Labour Commission or file a court case.
And because of that, they terminate me. That is unfair.
It's unfair. Now, the worker's gender, race, color, ethnicity, origin, religion, creed, social, political or economic status. Mr. B is an MPP man. I don't work with MPP people, let me sack him. Mr. A is an NDC man. I don't work with NDC people, let me sack him. All those are...
Or she's a woman, and by way of her predisposition at a certain point, I don't need her services. All
those kind of things. They are unfair terminations. And you have E, in the case of a woman worker,
this one is what Article 17 of the Constitution takes care of.
Clearly.
Okay, so let's go on.
So then where the worker is a woman, because you terminate a person's employment because she has become pregnant. That is an unfair termination. Then because the worker is temporarily ill or injured, and there is a medical certificate to that effect, you don't terminate just because it's temporarily ill. Of course, when the sickness reaches a stage where it cannot reasonably be expected to work.
So last week when we were doing the leave issues, there's a lady who called. If you are listening today, this is one of the things that resolves your issue. She said that she was on leave, and then when she returned, she was giving a number of excuses that while she was away, they didn't think she would come back. And here, as a woman who is pregnant, and then because of the pregnancy you are terminated, it is wrong. And the law talks about pregnancy of the worker or the absence of the worker from work during maternity leave. Then you talk about temporarily ill or injured and is certified by a recognized medical practitioner. Before that, there is also the question of disability. So disabled persons. Because the worker is a disabled person, let me terminate. It's unfair. Then also there is the one here where you are talking about qualification. If at the time of the worker's employment, the position that he applied to and was employed, the qualification that was required was A level. Now, after a number of years, that qualification for that position has increased to degree. You cannot say that because you don't have degree, I'm sacking you. What you are supposed to do is to retrain the worker. So the employer has a duty, an obligation. To train you, to bring you to the status level of the new, and the new threshold. The new threshold. And not to terminate your employment. Then there is the other one, which talks about refusal of a person to do work that another worker will normally do. But because that worker is engaged in a legal strike. You understand? If something is on strike, and I'm also working here, I'm not supposed to come and take over the work you do. And if I refuse to do that, the employer should not sack me because you are engaged in a legal strike. Now, there's a difference between an illegal strike and a legal strike. If it's an illegal strike, this provision will not. Then so, you have three, which is very, very important. Let me say this. Now, under this provision, subsection 3, that talks about a situation where it is the worker who actually resigns. You understand? Because
of ill treatment by the worker, by the employer of the worker. For example, sexual harassment and all that, and other circumstances for which you have continually complained to the employer is not doing anything about it. You as the employee or the worker can write to the company.
So my employer didn't sack me.
No.
I decided to move.
Yes.
Because there has been some ill treatment.
Sure.
And I have reported nothing has been done about it. Even though he didn't terminate me, it is construed that I have been unfairly terminated
by the employer.
Okay, we'll go to, there's a Vincent who has a question. We'll go to him, but before we do, if it is found that I have been unfairly treated or terminated, which is the grounds you have gone through, what can I get? What can I do if I have been unfairly terminated?
So we look at the remedies. But just before I talk about the remedies, there's this important point I want to make. The section 63 concludes by saying that your termination will also be unfair if the employer fails to prove. If the employer fails to prove, that the reason for the termination is fair.
If so the employer fails to prove
that
it is fair.
Exactly. So the onus is thrown back to the employer
to prove that
the termination is fair.
Okay. So if I am terminated in this covered era, and like you said earlier, they write the letter, they don't give any reason, and therefore I feel, you know, they haven't given a reason for which I can come under unfair termination, then I will challenge them that you should give a reason why I have been terminated. During that challenge, they must now prove that it doesn't come under any of these circumstances.
So
if they are not able to prove,
then the termination is unfair.
So if it's unfair, that's the question now.
Good. What happens?
Yes.
So you make the complaint at the National Labour Commission.
Okay.
Or in the court of law. And in the position used to be that some judicial Supreme Court decided that when it comes to unfair termination, you have to go to the National Labour Commission. That position has changed. As part of Sengbadere, where the court said no. The Supreme Court said no. The High Court has jurisdiction in all matters. Unfair termination is one of all matters.
So I go to the court and say what? And get what?
Now you file a writ, you seek the following reliefs.
So I can go to the court and I can go to the Labour Commission.
Whichever you choose to go. You can ask for reinstatement, where you will be reinstated to your position as to where before you were unfairly terminated. Then also you can paid compensation, or even both. So these are the remedies that you are likely to get.
Let's go to Vincent and come. But I also have understood that, particularly if it's a private organization and you ask for reinstatement,
they may not give you.
You may not. So you'll explain why. Hello, Vincent. Hi, Vincent. Let's hear you.
Hi, Samson. Good afternoon.
Afternoon.
And good afternoon to your viewers. I know a friend whose appointment was terminated while she was on maternity leave. So I want to find out, under these circumstances, what can she do?
Okay. Thank you very much. So I think we went over that, but for emphasis,
so like we said,
that would be unfair.
If the only reason for it is that she has given birth or is on maternity leave, that clearly is unfair. A person on maternity leave is supposed to be paid a full salary for the period of the leave. So it was wrong, completely wrong for them to have terminated if there are no other grounds for which she was terminated.
This person can go to Labour Commission to make a complaint of unfair termination, or can actually go to the court. But we all can't afford the court's legal fees. We may not be able to afford what happens in the Labour Commission. So what happens?
Yes, let me say that I concede that in the court it's a bit expensive. And the cost of filing alone is very, very prohibitive. Not even talking about the cost of engaging a lawyer such as Samson. You see? So one thing you can do is to approach the Legal Aid Board. It's now Legal Aid Authority, I think. Yes. They will,
so if you are somebody who can't afford,
who cannot afford,
but there's a threshold for people who are qualified to go to the legal aid board to get free legal service?
Yes, there is. But you see, when you go, those things are not taken out of consideration.
Okay.
They will look at your entire situation and see whether you qualify.
Okay.
But let me also add that when you go to the Labour Commission,
if you must be found to be someone who doesn't earn the minimum wage. Then you can be qualified as someone who's indigent, who is poor.
Exactly.
And then they will assist you for free.
For free.
Okay.
But if you go to the National Labour Commission, the services there are completely free.
That's right.
You don't pay for filing anything. You don't pay for services of anything.
You go there, they give you the form for free.
You fill it, submit it.
Okay.
If you think that the form is not wide enough for you to, enter your entire complaint, you can.
The form has never been enough for me. I always write plenty and attach it.
But the form is just supposed to provide a guide, by which you can now.
Okay.
So when you do that,
the
service, everything is free. Perhaps the only expenditure that you may make is your law refer to the commission.
Okay.
Which I think one should be able.
Right.
What I think is also prohibitive is about the locations of the offices of the commission. Because the commission now, as we speak, is in Accra, Takoradi, and I think Kumasi too has opened.
But according to law, you are supposed to be everywhere.
In every district. That is why government must do what is necessary to make sure that offices of the National Labour Commission are extended to the various
And that is when there will be true meaning to the fact that the Labour Commission is the place where the poor can go.
Exactly.
Those who can afford will go to the court. So, as we are saying, now we have found out where you can be terminated and it will be unfair termination, and therefore you'll be entitled to either reinstatement or reinstatement together with compensation or even damages to be granted to you. The small bit about where I mentioned that if it's a private organization, you may not get the reason. Explain that, and then let's go again on the question of under COVID-19. Strictly speaking, can you say a termination under COVID-19 is this kind of thing?
Very well. We'll come to that. You see, we have looked at the remedies for unfair termination, which include reinstatement.
Right.
Now, the practice has been that because a working relationship must be cordial, in private organizations, if you kind of force an employee onto an employer, you do not know what will happen.
Right.
Perhaps if the employee was able to get reinstated, you don't know what other traps they can set up for the worker. And so it is better under those circumstances to seek compensation for the employee rather than seeking for reinstatement.
Okay.
Because it may end up being
antagonistic. You can't even work in that office.
You can't work in that environment. However, if it's a public organization, the Constitution under Article 191 talks about a public officer cannot have his employment, terminated, removed without just cause.
Of course.
Public organizations, they belong to everybody.
Yeah.
So you should not.
And maybe if the office is in Accra and you think that to some other region, and your boss will still be fighting with you, you go to another place.
You go to another region.
Okay.
Let me also add that the ILO Convention, International Labour Organization Convention on Termination of Employment, ILO Convention 158, talks about the need for there to be a valid reason having to do with either the capacity of the worker to work or the conduct of the worker as disciplinary issues or the needs of the undertaker as being the three main basis upon which you can terminate the employment of a worker. But of course, that
now, before you came to unfair termination, you mentioned some of the grounds where the termination will be fair. And you mentioned incompetent or you lack the qualification in relation to the work for which you are being employed.
Yes.
Then it will be fair that you are being terminated. But in the qualification matter, if at the time of being employed, they required O-level, and then now things have changed and they require a degree, then it's the job of the employer to train you to that point, and they can't just dismiss you.
Yeah.
Then you spoke about misconduct, proving misconduct, and also redundancy can be fair termination. But there is one other thing which speaks to the question of COVID.
Yeah.
Tell me if it does not. It says, due to legal restrictions imposed on the worker prohibiting the worker from performing the work for which he or she is employed.
Yes.
So when there was a lockdown, there was legal restrictions by the states that didn't allow the worker to go to work.
Yeah.
Of course, the employer too could not also open the workplace. If you are terminated under that, that's fair, isn't it?
Yes, one may argue so, especially looking about the doctrine of frustration, where it is the position of the law that where circumstances are such that the contract for which you had signed cannot be carried, it's been impossible, it cannot be carried out.
Okay.
Then under circumstances, both parties may be discharged by the principle of frustration.
Okay.
That may apply. But I think that the lockdown was temporary. It was not permanent.
Right.
And once it was an intervention by the state, it was not enough to use that as a basis to immediately terminate the worker.
So under COVID, let's ask the question direct. Under COVID-19, my employer does no longer require 100 people to work with because there's no work. Right. He wants at least 50% of the people to go home. He's deciding to terminate. You say, how can he do it to be right? And when is it wrong when he does it? Let's listen to Victoria first. Hello, Victoria.
To ask, I work in a private school, and since the COVID-19, it's like we're not getting our salary. And even for March, we had half payment. So in this case, what should I do?
Have you been going to work?
No, we've not been going to work.
Okay. Your employer has not written to you to tell you anything about your situation at work?
Nothing at all, please.
Okay. You are teaching at, is it a nursery, kindergarten, primary, JHS? Preschool.
Yes, please.
Okay. All right. Thank you, Victoria. Yes, what do you say to Victoria?
Yes, you see, I think that her employer is making a mistake. The mistake is this. You are facing a difficulty. Your relationship with your workers is a contractual relationship. You are enjoying to invite them. This is the situation we are facing.
But
let us agree.
But the workers also know the situation.
Yes, but the workers know
the government says that.
You must formalize.
The government says that this class of people shouldn't go back to school.
Yes, government didn't enter into the contract with you. Okay. You must formalize the situation. So you agree that, okay, because of the situation, we can only afford half salary or a quarter of a salary.
Or no salary, because there's no salary going on
at all. What is important is that there is agreement between the parties.
Okay.
But the employer should not act unilaterally as if he had the right to do so.
You just mentioned frustration.
Yes.
Which is a principle of law that says a situation has happened, I didn't foresee it, I don't have control over it, and it is making it impossible for me to perform the terms of our contract.
Yes.
So that's frustration. He's frustrated, isn't it?
If it were that frustrated, he would not be paying half salary to them. He is still interested in the relationship. The employer is still interested in the relationship. So you must formalize the new situation.
Okay. All right. So there must be new terms.
Exactly.
Novation of the contract.
Agree. Then let us now do this because of the situation.
Michael. Hello, Michael. Michael, let's hear you.
Good afternoon, and thank you for this opportunity, Samson. Please, in respect of
Michael's line is bad. Okay, so
what you said about the employer based on the certificate you were employed with, and if later on the position that you are holding that is above the certificate you brought in, what about if your employer demote you from the position that you were?
Okay.
When they accepted your certificate, what can you do?
All right. Thank you, Michael. Yes, Charles.
The employer is not permitted to vary your conditions of service unilaterally.
Okay.
without negotiating with you. So if that happens, it may amount to a situation of redundancy.
Okay.
And so I think he needs to engage the employer or seek the necessary legal redress as we have explained
the
here.
overriding thing here is mutuality, consent.
Exactly, consent,
needing
negotiation.
to sit down and negotiate.
Yes, and negotiate.
Okay.
You cannot vary the employment of a worker to his disadvantage without his consent.
Okay.
The Supreme Court has said this.
All right.
So, yeah.
All right. Okay, so Michael, you heard that. Yeah, you said who else? Mark. Hello, Mark.
Hello.
Yes,
can you hear me?
I can hear you. Charles Baudia is listening to you. Go ahead.
Yes, greetings to all of you. I just want to share a few thoughts on the topic under discussion.
Quickly.
What I have realized is that the employment relationship is supposed to be mutual. But because of the unemployment situation in Ghana, it has given the employers more power as compared to the employees. So this is really affecting the relationship. So employees are unable to even stand out for their rights.
Okay.
And a little on the situation COVID with termination. When you look at our situation now, there are public school teachers who have been home from March to this time. They are not incurring any form of cost by receiving their full salaries. My appeal to the government will be that it should look upon the private school teachers. As the woman shared with us, I mean, for about 4 to 5 months now, she has not received anything in the form of salary.
Right.
So if government can support some of these individuals, it can also cut down that of the public school teachers to support the private school teachers so that there will be some kind of balance in the system. Thank you.
All right. Thank you very much. And thank you all for joining us and sharing your thoughts. Unfortunately, we are not able to pick any more of your questions. So Victoria's issue was not actually that she was receiving some salary, but not at all. Your emphasis is that the employer still needs to call them, even though they are all aware of what is going on.
Exactly. They need to call them or write to them.
Okay.
If the contract is frustrated because of what has happened, you will write.
Okay.
Formally end the relationship. Formally end the relationship. You do not leave it hanging.
Okay. But do they have any sort of recourse in the circumstance where they don't write to them, nobody calls you to tell you anything? Can they do anything about it?
Oh yes, they can always make a complaint to the commission or go to court.
Okay.
And at that point, they will be compelled to give an answer. They will compel
and they will come and say because of COVID-19.
So the adjudicating authority will now look into it to see whether that approach was justified.
Okay. As we were told by the finance minister, you know, he reported to Parliament on Thursday and said that the impact of COVID-19 has been devastating on the people, business, and the economy of the world, with 2.2 billion jobs. That is 68% of global workforce under threat. So COVID-19 is real, and employees must also think about it, that they will lose their jobs. Is that not the case?
Certainly it is. And that is why we say that this relationship is mutual. And the sharing of information is what will inform the employee's position. If the employee knows that the situation is that bad, the employee will not be such unreasonable to say that I must get my pound of flesh.
I work in the aviation industry. I know the borders have been shut. No plane is flying. I am in the hospitality industry. I know that because of COVID-19, practically nothing has gone on. The hotels have been empty. I still must expect my employer to write to me formally to say, because of this situation, we don't need you anymore.
You see something? You can remain employed without being paid.
Explain that.
Yes. You can have you know, the issue about salary in the Act is that you should be paid the agreed salary. So it's about agreement. So if you have agreed that no salary will be paid for a certain period, even though you are still an employee, you are not being paid.
Okay.
So if that's why sometimes you can have a worker taking leave without pay. He remains an employee, but he's not being paid because that is the agreement. The entire thing is about
Is that what you call a fellow?
Yes, the entire thing is about mutual agreement. So that if the situation is such that because of COVID-19, I'm not working, I don't have anything, that arrangement must be made. Let us agree. Employer-employee agree that because of the circumstances, we are suspending payment until the situation improves.
Okay.
That is good because the worker knows that he is still employed.
Right.
If the situation improves, I will walk back to my employment.
All right.
So negotiation, agreement, mutual discussion is very important in this COVID era when it comes to employee-employer relations.
Okay. And as far as you are concerned, even though we are in COVID and it might look like some of the employment relationships will come, that the employment agreement will come under frustration, must it not be in the terms of the employment contract that, you know, a situation may come which will frustrate or will be a question of what is known as force majeure?
Yes.
Must it not be there before the employer can activate it to his benefit?
You see, first of all, let us understand that employment law is also contract law.
Right.
That is the larger aspect of the law of employment, which is contract law.
Okay.
Now, somehow, legislation has made interventions as to some aspects of contract law which they think should not apply to labor.
Okay.
And have made provisions in those legislations.
All right.
So those ones will apply. But where you have situations which are not covered by the Act or some other legislation or an agreement made under the Act, such as a collective agreement, you go back to the common law principle on contract.
I cannot together with my audience and production team, thank Charles Bawadria enough. Charles Bawadria is private legal practitioner and former Executive Secretary of the National Labour Commission. I am all smiles because of how he seems to have the law in his bosom, just dishing it out in the way he has done. Thank you very much for this afternoon, sir.
You're most welcome, sir.
Thank you. Okay, so this has been covered under law. This is your legal light and health law in these trying times. I am Samson Ladi Anyanini. Have a good afternoon.